Welcome to Conversations with Cayuga Drug and Alcohol Testing. I'm Brian Muldrow, owner of Cayuga Drug and Alcohol Testing. Today's episode is the legalization of marijuana and the impact it has in the workplace. Today, we'll be interviewing Jessica Kolodzie. She's a 20-year expert in HR with a master's degree. Jessica, could you please introduce yourself?
I have a degree in business management, master's in management, and I have been in HR for over 20 years. As started out entry level 20 years ago, drug testing was very different from today. So, as a senior leader, the world is changing. So I'm excited to be here today to talk to you about what's going on in New York State and beyond.
We'll be interviewing Andrew Easler. He's an expert in this field. Andrew, please introduce yourself.
My name is Andrew, and first of all, I just want to thank you for the opportunity to come on here and share hopefully some insights on the changes to drug and alcohol testing regulations. A little bit about me. I used to own a successful drug and alcohol testing business for a long time. I ended up selling that off and focusing just on the training aspect. So we at Easler Education, through our website, drugtestingcourses.com, help train employers and pretty much any person involved in the drug and alcohol testing process on how to do their part. So part of that is also keeping up to date with the regulations. So personally, I have my Juris Doctorate from the Florida Agricultural and Mechanical University College of Law. And I have worked as an expert witness and a subject matter expert for the last 6 or 7 years. And I am so excited to discuss some of these crazy things coming along the horizon here in New York specifically.
Well, thank you for joining us. So let's get right to it. So the laws have changed in New York State. Right now, marijuana is going to be legal for recreation use. How do you think that is going to impact our industry as well as the HR professionals in New York State that have a current drug policy? Andrew.
Yeah, I wasn't sure if you were asking me. Just wanted to make sure. So I think once recreational marijuana is legalized, we really have two different paths forward. So Governor Cuomo introduced the Cannabis Regulation and Tax Act. And then we also have the Assembly and the Senate in New York that has been trying since 2013 to get through their version, which is the Marijuana Regulation and Tax Act. So each version is very different. But when it comes to employers, they're mostly the same, and they have some of the similar goals of trying to correct some of these racial injustices that have happened over the years because of the criminalization of marijuana. So when it comes to employers, though, we really have to figure out which one they're going to end up going with. We have, if they go with the MRTA, that is a very employee-centric policy, which basically means that an employer can have a drug and alcohol-free workplace policy and continue to hold it once marijuana becomes recreationally legal. But in order to enforce that policy, they really have to have specific articulable observations about that employee's behavior that would actually substantially impact that employee's performance in the job. So not only do you have to observe phenomenon that would tell you, hey, this person's under the influence at work, but then you have to also take that further and say, do these side effects of marijuana use now impact their ability to do their job? So if you imagine you have somebody who's coming to work and their eyes are bloodshot and maybe you smell marijuana on them, but they're not staggering, they don't have no uncoordinated movements or anything like that. Now you have to make that determination as the employer. I can take an adverse action at this point, maybe try and do a drug test, but even then that drug test is not going to be conclusive proof under MRTA. So now we have employers in a really tough spot, right? So they need special training on, number one, determining whether there is reasonable suspicion to test. And we do training like that at drugtestingcourses.com. Or, if there's not, then, how do you deal with that specific situation? So there's a lot of crazy things that are going to have to get ironed out as things move forward. But I'm excited to see how the courts deal with it as well.
The follow-up question to that is, some employers are fearful of testing their employees due to the fact that, basically with the laws being passed in recreation use, seems to be a lot of people that are indulging back into marijuana. Like, what would you suggest how an employer could deal with that type of situation, and if they had it in the workplace, if they wanted it or they condoned it? Because there's sometimes they condone it, and sometimes they don't want that in their workplace. Do you have any suggestions for that, Andrew?
Yeah, great question. So, I think one of the goals of the MRTA was to basically say, hey, listen, it's the policy of New York to say employers shouldn't be regulating legal off-duty conduct. And that's something you see across the United States, in many different states that have a broad law in employment law, that basically prohibits an employer from doing something like that, basically reaching beyond the scope of that contractual employment relationship to try and control what the employee is doing on their off time. Well, New York State in that MRTA basically says that's the policy. We don't want employers to be able to go and say, you shouldn't be drinking on Sunday on your day off. Same thing with marijuana. They want, we don't want employers to be able to say that. On the flip side, even if you're an employer who says, I don't really care if my employees are on marijuana, you should care if they show up impaired, right? Because even if you work in an office position, even if you work in a generally non-safety sensitive function, we do have a lot of studies that do indicate that impairment can affect a lot of other things, not just safety, but we're talking productivity, absenteeism. There's a whole host of other issues that can happen. And now we get to the argument and the conflict between just the presence of marijuana in the system from something that you're doing legally on your day off to the presence of marijuana in your system while you're impaired. And we have to make that determination now as the employer to say, okay, how can we determine if we have somebody who's physically impaired by the psychoactive effects of THC, or somebody who merely has the metabolites in their system and is no longer experiencing those effects. And that's really probably the root of the problems that we're seeing, trying to suss out how we deal with recreational marijuana throughout the United States, not just in New York. And so part of that for me as a recommendation is to actually switch from a urine-based test, which will go up to about 30 days of use. So basically, if somebody is a consistent user of marijuana, they're going to have that metabolite in their system, even if they stop using marijuana, for up to 30 days, right? So that's a really far way back for something that you bet as an employer, you can't tell if that's actually something that they were, was in their system at the time that they were working, or something that they did on their day off. So switching to a saliva based or what we call oral fluid drug test for marijuana will actually reduce that window of detection. And that'll tell us usually between 4 hours. Actually, some of these, there's studies that do conflict. So some of them can detect it as early as 30 minutes. But really the maximum time period for marijuana use is about 24 hours. So that's going to get us a lot closer to what we're looking for, which is, are you impaired at the time that we do this test, right? So it's a much closer window. You don't have to go back and work with these urine tests up to 30 days. So that's what we're seeing a lot of employers do in these states that have legalized recreational marijuana specifically.
Just one follow question to that. Obviously, we have non-DOT that would be applied. Do you foresee the Department of Transportation making any changes to their policies? And have they done that throughout the country, like in other states?
Yeah, great question. So, the DOT, I hesitate to make predictions. They have surprised me and surprised me and surprised me. The DOT gets their mandate from Congress, and Congress has begged them to adopt both hair and saliva testing procedures since I think all the way back to 2014. And they basically gave them deadline after deadline after deadline, and they kind of dragged their feet a little bit as it came to it. And they finally adopted them, the Department of Health and Human Services, which is the other federal agency that helps develop these drug and alcohol testing regulations across the country. And the question is now, it's up to the DOT and their sub-agencies to determine if and how they're going to implement those oral fluid testing protocols that are now adopted, right? So we need one agency to go forward, like the PHMSA, Pipeline and Hazardous Materials Safety Administration, to say, you know what, we're going to use oral fluid for post accidents, right? Then at that point, now we'll have the door open for people to go out there and properly get trained and qualified and approved to do these kinds of things on the federal level.
So Andrew, I wanted to ask, as an HR professional, we are used to certain employees having exceptions. Perhaps they had a prescription for marijuana or some sort of opiate. And, we've managed it in the past based on whether or not we deemed it safe for them to do the job that they are required to do, and perhaps providing reasonable accommodations. How do you see this changing? Has there been recent case law regarding the reasons employers are using as being valid and authorized? I know there's lots of discussion around discrimination and such. So I just wonder what your thoughts are around this and how the world is changing.
Yeah, that's an incredible question, and something that every employer should be asking. At this point, unfortunately, not everyone is even, it's not even on the radar. So it's a really good question that you asked. The history of it falls back to the Supreme Court. They had some cases out of California, which basically said, that marijuana, even if it's legally prescribed under state law, is not something that falls under the ADA. Right. And then most states have basically adopted that federal standard to their state disability discrimination laws. That is starting to change. So you see states, when they're starting to enact their legislation, I believe Rhode Island, when they did their medical marijuana legislation, they said, hey, if you're legally prescribed marijuana, then an employer cannot discriminate against you for that lawful use. Now, obviously, just like an opiate prescription, if it's going to impair your ability to work in a safety sensitive function, then obviously we have another issue, and we can accommodate that just like any other prescription, like amphetamine, like Adderall or something like that, if it's really going to impact your ability to do your job. Now, this is where we see the distinctions between the MRTA and the CRTA. Right. So MRTA says, hey, listen, it's a disability under our state law and you can't discriminate. Right. Obviously, you can do the safety sensitive, basically following that Rhode Island model, or the CRTA, which says, hey, keep everything the same as it is. The important thing is to make sure that we're looking for actual impairment at work rather than just the presence of some metabolites. We're looking for THC in that drug test. So it's a little bit more employer favored.
Mm-hmm. Now, in a manufacturing setting, how far can employers go when it comes to perhaps a floor worker who can legally, they've got their doctor prescription, but it just doesn't seem safe to have them out there on the production floor. And that's, the only role that they're qualified necessarily to do. How far does an employer have to go with that?
It all depends on which law we end up adopting in New York, right? So that's something you're going to have to hopefully reach out to your local congressman and politician to voice your support, because if you go under the MRTA, somebody working on the line is going to get a lot more protection. And if you feel like they're working in a safety sensitive position that you can't eliminate the safety risk, you're in a tough spot. And it, for me, it doesn't seem a little bit fair to accommodate. Looking at how things have played out in New York City, I personally, this is my personal opinion, I feel like there's a lot of arbitrary decisions on what's exempt from the marijuana use. They basically designate certain safety sensitive positions based off of their commission, and the commission is not necessarily an employer, right? The employer knows their positions better than some politician or bureaucrat. But we'll see how the laws play out, because in that specific scenario, I think the CRTA gives a lot more power to the employer to say, you know what, this is not something that's working for us. Now, under either the MRTA or the CRTA, an employer still has the ability to prohibit an employee to bring any of those paraphernalia onto the workplace. So if you have somebody who's got their lawfully prescribed marijuana and they bring it into the workplace, of course, that's something that you could take adverse action against for violation of the drug-free workplace policy.
Got it. Okay.
Andrew, I got a question for you. I was wondering, what would you think about marijuana seems to be the main issue at this point, right? So I think that most employers will not turn a blind eye to some of the harder drugs than marijuana. There has been people that came to us and asked us to exclude marijuana. And I just want to know your thought process in that. Should that be standard practice for a business? And the follow-up question was, when you were talking about the saliva, you said that the urine test goes back 30 days. Saliva, you didn't give a time frame. I don't believe I missed it, and how far saliva goes back, so they can get more of an accurate count if somebody's actually using it while they were on the job or maybe happen to be under the influence.
Sure. So hopefully I remember both sides of that question. So I'll start with the first one, which is employers that are leaving out marijuana from their panels. That is something I would probably not advise, even if you feel like, hey, listen, that we're okay with you using it over the weekend. Instead of removing it from a panel altogether, what you want to do is switch over to something with a shorter detection window so that you still have the ability to run the test. It's going to give you a much more close relationship to actual impairment. And then that way you can cover yourself from the liability aspect, because I'm imagining scenarios where, you have a reasonable suspicion. You've observed an employee who is completely under the influence based on your specific articulable observations about their behavior, their speech, their, appearance, all these other things that we need for reasonable suspicion. You run the test minus the THC panel, which if you are going to change your panel, make sure to update your drug-free workplace program as well and give notice to all of your employees. But if you take it minus the THC, and you do the test and it comes back negative, you put this person back to work while they're under the influence and they cause an injury to another employee, let's say. Now, does that employee have a cause of action against the employer for negligently allowing that employee back on the line in a manufacturing setting, even though you had the opportunity at that point to catch that possible risk and you didn't?
That's a good answer. The second part of the question was the saliva. Like you said, there's ways of testing. I know the answer, but I want you to say it, right? That will get a quicker response, a more accurate. What is obviously we know the urine is going to go back 30 to 45 days. What is the time frame?
Sure. So, go ahead.
The quickest time frame possible.
Yeah, so I've done quite a lot of research on all these different things. And if you look at some of the medical research, the time periods vary because every person is different, right? So if you take 100 people and do tests on them and they all, have something in their system at the exact same time, they're going to have a detection window that's different for each person. Now, that being said, there are some studies that put oral fluid at 30 minutes after use. So somebody smokes a joint, 30 minutes later they come into work, they do a saliva test, that THC is going to show up in that test, okay? That's one study that I found, I think it was out of Australia. Most studies put it at between about an hour, and then usually the max is about 4 hours rather than that 30-minute. And then the maximum where it's going to not detect something after that time period is 24 hours. So you're looking at as little as 30 minutes after use up to about a day after use for most substances. So that's why saliva is becoming more popular in these, particularly in these states where they're legalizing recreational marijuana.
Andrew, I just got one final question for you. In most states that you can get workman comp discounts and some insurance discounts for having these type of policies. And can you explain on some of the savings One of the savings is preventive savings for any lawsuits or any injuries. But also there could be a savings from your insured company.
Yeah, so in these states that have basically adopted what we call a voluntary drug-free workplace program, they basically incentivize employers to adopt a policy that conforms with what they outline in their law. So they say, hey, listen, if you adopt a drug-free workplace policy within the parameters that we set forth, we're going to give you all these goodies, right? One of the best goodies that they give you is typically a premium discount. So it can be anywhere between 5% to 10%. Some of them start out at a higher, like 10% premium rebate, and then kind of go down gradually. I think Georgia does that. Some of them give you just a full lifetime premium discount as well. Other times they'll add on to that with certain legal protections when it comes to liability. So for example, if you have a workers' compensation case, somebody's injured, you run a drug test in a post-accident situation, that person is tests positive. If you've adopted a drug-free workplace, let's say in accordance with the Florida law, you have a presumption that that injury that employee was involved in was caused by their inebriation, that they were because of their intoxication, because they had that positive drug test. So it actually is very, very, very helpful for employers to adopt those kinds of policies legally, right? So it helps. They typically affect not just workers' comp, but also unemployment claims.
Now, you had said something earlier, and most policies are including those four common scenarios: the pre-employment, post-accident, random, and for cause or reasonable suspicion. So with these laws, how does that change? How is there anything that is not advised anymore, or should there be another scenario or a rewording, so to speak?
Yeah, definitely 100% reasonable suspicion is going to have to change in New York with either one of those, CRTA or MRTA. You're going to have to, again, not only determine that you believe somebody's under the influence, but also that that is going to impact their ability to perform. So that's going to be something that you'll definitely have to work on that policy. Now, when it comes to random testing, I don't remember seeing anything about the prohibition of random testing in the MRTA. I know that the CRTA didn't change that at all, but I'd have to look again because it would be something that I would see the drafters of the legislation add in as something that they don't like. So I'll look again and and then follow up with Mr. Muldrow here and give you the answer on that one. But in general, I think reasonable suspicion is probably going to be the most impacted.
I do wonder, as things change, and certainly COVID has changed the way that the workplace functions with, I know in our, industry, manufacturing has had to do things to spread staff out, change shifts, make sure we don't have staff around. So there's people working different hours than perhaps their managers, just to have fewer people in the workplace. And, I wonder with reasonable suspicion and such, what is recommended as far as training managers or leads, or typically with someone who held a supervisor title. But with COVID going on and having different populations in charge, I just wonder how that's changing.
Yeah, great question. So the DOT specifically mandates reasonable suspicion training for anybody who's basically acting as a supervisor of somebody who's working a safety sensitive function. We call it covered under the federal regulations. So that's not going to change. You're always going to need to have that. Now, when it comes to non-DOT, which is basically what we call anything that's under your state law and your company drug-free workplace program, you're going to have to look at that and see how it's worded first in your drug-free workplace policy. Now, I can't give legal advice at this point, but definitely work with an attorney potentially to review your drug-free workplace policy and say, okay, so does this still work to how we've decided to adapt our work environment? If you don't have that traditional supervisor designation. But if you look and see, well, this person is now this, line supervisor who we wouldn't consider a supervisor before under our policy, is now performing those functions and is kind of like our last line of defense. If there is somebody who is coming in under the influence, maybe we should look at making sure that they get that special reasonable suspicion training so that we can do something if we find out that somebody does have a problem and they're at work creating a hazard for somebody else.
Great, thank you.
Well, I want to thank the both of you for joining me. I learned a lot, and thank you, Jessica, for your expertise and your great questions, and Andrew sitting through this and answering these complicated questions in this complicated world in this complicated time. So I really appreciate you. Thank you.
Thanks for having us.
All right.
Thank you.
I think it went well. Andrew, man, you were really knowledgeable about drug testing. I'm gonna tell you that right now.
Yeah, I'm a nerd.
I didn't want to say that. But I'll tell you, man, that is really good. And I'll tell you what I learned from this. Doing what I'm doing, you guys trained me very well, is that people are scared to test their own people. Like, that's the number one, unless they had a policy before and they just kept it. And then they're gun shy. And, Kirsten was telling me she had this one case where, people got injured and they still didn't want to test them. So I think that the saliva thing, what you said, is something I never thought of. Because that means somebody was high on the job. The saliva is strong. I think that is going to be a new approach for us, because I didn't think of it, because I always thought the saliva is the easiest one for them to cheat.
That's actually one of the hardest ones for them to cheat, in fact.
Really?
I've heard of employers that we'll do our onboarding all at once with 30 or 40 people and just kind of hand out the saliva kits without doing a one-on-one test. So they're doing a big, 30-person onboarding in one big giant room. And if you're not watching the person, then you might have some tomfoolery going on. So obviously I highly advise against doing something like that. But when it comes to saliva testing, if you get somebody who's properly trained and qualified to do it, you're never going to have cheating. It's literally impossible to cheat a saliva test. Wow. So, I think, that is for sure going to be the future of the drug testing industry. How long it takes for that to change, I don't know. Our industry is extremely slow to change and to adapt to the times. So we'll see. I mean, one of the other reasons I think that you were saying employers are hesitant to test their employees. Number one, you can see where the trends are going, right? So, when it comes to the courts and the legislatures, if there's a new law that comes in place, it's not going to be favoring the employer, right? It's going to be very employee rights centric. Now, how strong that is going to depend on the political party in place, I think. But so that's one thing people are hesitant. Hey, listen, if it goes bad, I don't want to be on the receiving end. The other thing, people want to be friends with their employees. They don't want to be, they're also averse to conflict. They don't want to deal with the confrontation of, look, buddy, I found out that you actually do have a problem. But a lot of people don't realize that this is probably the best thing. This is part of your employee health, right? This is how you maintain a healthy workplace. If you can't identify when somebody has an issue or a problem in the workplace, you're going to have major problems throughout the rest of your workplace as a result. So that's another thing. You don't want to let that stuff faster.
And I think 2 hours, think about it. You said that first the saliva test go back 2 hours. I think that's pretty. I mean, that'd be, they literally were doing drugs right before they came to work.
Yeah, like I said,
that would spook me if I was an employer.
Right, and that's what you want. You want to know if they're doing that, right? If I'm an employer, and I have a Monday through Friday, the majority of employers just say, what, do whatever you're going to do on your day off, which is what New York said. Hey, it's our policy. We don't want, employers to be able to regulate what they're doing if it's illegal, right? If somebody goes to Amsterdam and smokes marijuana, technically it's legal there, right? Even in the United States, still a controlled substance Schedule 1, which has kind of been our number one barrier as employers to fall back on when the state has said, it's legal. But when it comes to federal, hey, listen, the state courts are like, hey, we're going to defer to that. The Controlled Substances Act, it's illegal, so it definitely doesn't count under ours, which is what Colorado kind of did. California did. Anyways, a bunch of other states are kind of falling back on that, but now there's legislation in Congress to remove it from Schedule 1. So that's going to make some waves down the road as well for employers.
I've always most curious to hear what other employers do when there is that reasonable suspicion. You really believe that someone is under the influence. One of the current processes is trying to find them how to get them to the lab, where to go and test. And it felt like the liability is there to put them in a car and go. So, there's always that discussion of, do you, just get them?
I have an answer for you, Jessica.
Oh, do you? I bet you have an answer.
And I come with my little mobile bill and I will test that person on the spot.
Yeah.
And you would have an answer shortly if he's under influence at that moment.
Well, you pull the person in, you say, we have a concern, we're pulling you off of the floor right now. And then what? There's this awkward, how are we going to get them to get a test? And how can we make sure they don't have the excuse of sitting in the lobby? Oh, they couldn't get me in. Now all that time passes and, oh, I'm going to go the next day. And then it's out of their system. So it is really interesting, to think of having it be right there. We call you, you're ready. You're right there in the lobby, ready to go, ready to come and, do it on the spot. So, that's a nice benefit to the employer to kind of take that question mark off, and then we can be sure that, yes, they have a reasonable, or they have it in their system and we can safely get them home or tell them to call for a ride, all that. But then the other scenario that I wondered about, and Andrew, I wonder what you're reading about, since you clearly are very current on this, is, I hear about it in the HR articles and such, but what do you do with the work from home employees that you suspect are under the influence? Happy hour begins a little too early, or they look a little more than sleepy.
You've no idea how many employers I have tried and begged to switch to mobile testing on a reasonable suspicion or post-accident testing circumstance. Yeah. Because I'm like, why would you put that person in a vehicle? Now you've got two employees that you're driving, to a facility. Yeah. Or Lord knows, could you imagine if you sent them by themselves? Here, go, drive your own vehicle while you're suspected under the influence, right?
It's like, well, that's just switching it around. So yes, I was under the influence. I was not of right sound mind, and you put me in a car.
Exactly. So. Right. So, I think it would be distracting, that's crazy. So mobile testing is literally the best solution for that situation. Get somebody out like Brian or, one of his employees to your facility, have them test them on the spot. I could tell you so many stories of fun situations of doing that myself and arriving at facilities and, employees are just like asleep, lost their continence right there at their desk and, a big bag of empty bottles of wine and, anyways. So getting to I'm sure 20 years, I'm sure you've seen a lot too.
Never at my employer, no.
So work from home, that's fun. I think the first thing anybody should be doing before they start looking at solutions is probably looking at your state laws. We have a whole course on every state law in the United States, and every state law is going to be different. So if you, for example, don't have enough suspicion to order that test because you can only observe through this minor window here of what's going on. Oh, that person's hair is a little bit disheveled, right? They didn't comb their hair. That's one thing, right? That's not going to be enough for you to say we need to order a reasonable suspicion drug test, right? So how much of what you're seeing, of what's going on, that you've been able to document, that you've been able to specifically observe, if there is a problem. We basically have, two scenarios for reasonable suspicion. We have an immediate action, and then we have one that we kind of have to document over a longer period of time, and then you can maybe even call them in. Once you modify your workplace drug-free workplace policy to basically accommodate this work from home scenario, you can send somebody like Brian to their home.
I'm finding out that not everybody is as professional as you in the HR field, Jess. And I'm getting these phone calls like, let's go. I'm like, no, you can't go right now. So I just think that you got to write a policy. We'll put an agreement together, if you or anybody would out there, that shows that what our accessibility is. And we have emergency 24-hour. We can do 24 hours, so we can get there. All right. Anything else, Jess?
No, I'm good. This was a good conversation. So thank you.
Thank you, guys. I really appreciate it.
Great to meet you, Jessica.
Nice to meet you. Thank you.
All right.
Bye.
See you, Brian.
Thank you for joining us. See you next time.